Hello and welcome. We're discussing Your Chance for Change, Shaping the UK's Fertility and Embryo Law. The hashtag for this event is HFE Act. This event is taking place thanks to the kind support of Merck. I'm Sarah Norcross, Director of PET, and I'm chairing the discussion. When thinking about the future of the fertility and embryo law, I think it's important to reflect upon the past. And our origins, those of Progress Educational Trust, PET, can be traced back to 1985, when the MP, Enoch Powell, sought to pass a law that would have made human embryo research and IVF illegal. A campaign was mounted in defence of fertility-related research and treatment, and Powell's bill was ultimately defeated. The Progress Campaign for Research into Human Reproduction, which was the name of PET's precursor organisation, then continued its work, seeking to ensure that embryo research and IVF could continue. The public education and parliamentary lobbying work culminated in the passage of the Human Fertilisation and Embryology Act in 1990. This law still sets the terms on which the work with human embryos is permitted and regulated in the UK, and it has been emulated in many other countries. The late, great Baroness Mary Warnock chaired the Committee of Inquiry into Human Fertilisation and Embryology, and it was that committee's report that laid the foundations for the 1990 Act. And PET was honoured to have Mary as a patron. PET has continued to play an active role in policy debate ever since, and was involved in some of the major updates to the legislation in 2008, such as the removal of the consideration of the need for a father by clinics when providing fertility treatment. Our most recent success was our campaign to extend the limit on storage for eggs for non-medical reasons. In relation to the Act as a whole, though, we've been calling for a thoroughgoing update since our annual conference, Make, Do and Amend, Should We Update UK Fertility and Embryo Law, back in December 2018. And now the fertility regulator, the Human Fertilisation and Embryology Authority, the HFEA, has a consultation which is now live. And that is the first step in making any changes to the law a reality. Though I'm sure that the HFEA's chief exec, Peter Thompson, who's speaking this evening, will quickly remind me not to get carried away and that a consultation does not guarantee change. But Peter, I'm an optimist and a campaigner, and also I believe in the old adage, if you don't ask, you don't get.
I'm an optimist too, Sarah. I'm also a realist, so hopefully we can combine both of those features. And what I want to do in 10 minutes is give you a bit of a whistle-stop tour about what's covered in our consultation, and in particular, should it come to pass that these kind of changes are made, what we think the benefits might be. Before I give you a bit of detail, what is the case for change? As Sarah said, the Act itself has a long history, groundbreaking in 1990, updated once in 2008. And crucially, it seems to us over those 30 odd years, there's been a really quite significant change in the variety and types of people actually accessing treatment. Clinic ownership has changed significantly over that time. This is one of those rare bits of medicine in this country which is dominated by the private sector, and that has taken on a very different character over these years. The sector itself is both larger, but also offering a whole range of kind of ancillary services that certainly weren't present back in 1990. I think there's been changing attitudes more generally as well to fertility treatment. One thinks about sort of attitudes around, for example, the openness with which such a subject is now discussed, which I think 30 years ago was most definitely not the case. The science has clearly moved on a lot, and there are now some potential treatment options not far over the horizon, which very much push against what the Act allows. And regulation itself has changed a lot over the last 30 years. So the consultation itself is divided into 4 themes. Broadly, they're about patient safety, access to donor information, issues of consent, and scientific developments. And I'm now going to give you a quick whistle-top tour of each of those 4 themes before looking at benefits. So if we go to a section entitled Patient Safety and Promoting Good Practice, a few highlights from that. I think one of the things that's very striking about the HFEA Act is it gives the regulator some quite draconian powers. We can close a clinic down, suspend a service and the like. But actually getting to use those powers is very tricky. And more to the point, actually, unlike a lot of regulators these days, we don't have what you might call is a graduated ladder of enforcement. So we are faced with a problem sometimes where those sorts of powers seem disproportionate to the kind of non-compliances and problems we're trying to deal with. Other regulators, many other regulators, including, for example, the CQC, have, for example, powers to levy financial fines, which may be more appropriate. There's also a sense, isn't it? The Act is constructed around the idea that all treatment takes place in a licensed premise. But in fact, now quite a lot of treatment takes place online or in other sort of satellite type arrangements where ancillary things like wellness and well-being go on. Now, from the perspective of the patient, it seems kind of odd that only one bit of their experience is actually regulated. And the other thing that's quite surprising, and I think dates the Act very strikingly, the Act has a great deal to say about protections offered to the embryo. You have to look long and hard to find any discussion of protections for the patient. There's a huge absence around that. So that, I think, is the first area. The second is access to donor information. Many of you will know that in 2005, the law was changed such that donation can no longer be anonymous. And indeed, 18 years, once you reach a donor-conceived individual reaches the age of 18, they can get certain access to certain specified information. Since that change, I mean, the world has changed quite significantly via social media and cheap consumer DNA testing, which calls into question whether the kind of confidentiality envisaged by the Act is even a practical proposition anymore. So one of the things we're consulting on is the idea that effectively parents could make a choice from the off about whether they wanted to use a donor who was prepared to have that information available at an early stage in the child's life, or whether they wish to continue with a regime pretty much like the one at present. Regardless of that choice, we think that those using donor services really should have implications counselling about the decision before starting treatment. And we also think that there's a sort of responsibility on clinics, which really can no longer be an optional thing, about informing people when they make that decision at this point of treatment, that if they do opt for the sort of anonymity until 18 sort of route, that actually that's something that's difficult to promise in the sense because of the developments I've just talked about. Which brings me on to consent. Consent in fertility treatment is complex. It's partly complex, of course, because the law is complex, and in a sense, because one is creating families rather than just treatment on an individual, it is necessarily complex. It's also true that although there are occasionally sort of complaints that HFEA consents somehow duplicate other medical consents, for the record, they don't. The consents we require clinics to do are only those required by the Act itself. All of that said, one of the things we're consulting on is the idea that could we try and simplify the consent regime a little? We've floated in the consultation the idea of a kind of opt-out mechanism, and I can say more about that if people are interested in questions. Two more discrete things is there is a degree of confidentiality about patient records, which I think has long outlived its usefulness. And so actually we think that there should be changes to the law to allow much easier record sharing between clinics and the wider NHS. We think that's good. It's found elsewhere and will be good for patient safety. We also think there's a case for a loosening consents around research. At present, effectively, somebody has to consent to almost do a specified project in a clinic that has some kind of relationship to a research project. We think that means that fewer embryos are available for research than is ideal. And when you think of the benefits that can flow from that, we think a more generic research consent is worth doing, which takes me to my last theme, scientific developments. There are two issues here. One, I think, is about a regime that is more able to encourage innovation. Currently, for novel treatments and the like, the barrier to entry is high, but there's no approval controls. We think actually the barrier to entry should be lower, but actually we should have the opportunity through sort of organized sort of trial approvals to have greater control, particularly in the early stages, so we can see how things, low risk things actually pan out in the real world. And we also think there's a case for building in greater flexibility into the Act. An example here might have well been with mitochondrial donation in the 2008 Act, in which the Act was constructed in such a way that it was possible then via secondary legislation to allow mitochondrial donation when the science had sufficiently moved on. We think that's a general model that might be well adopted. So if that's a quick overview of the consultation itself, what about the benefits? I'll be quick here. So the benefits to patients, if you took all that in the round, we think that it would give us as the regulator a much more effective set of powers to tackle poor care where we find it. We think that an explicit recognition about patient care would also help the regulatory system put patients, if you like, at its focus. We think extending the remit in the way I've talked about would give a much more holistic approach to patient services. The streaming of information, the sharing of information would also deliver improved care. A more streamlined consent process, I think, would make life a little easier for patients. And we think this would give more choice to donating embryos to research. From the perspective of clinics, we think, in a way, this ends up with a slightly more flexible regulatory regime that incentivizes improved performance. So under this regime, we could look at longer periods between inspections, so that would be a bit more proportionate for a well-performing clinic. So if you like, it's a lighter touch where clinics are performing well. We think there are measures, the measures we're suggesting about sharing a PR role would help clinics significantly. We think also where poor performance is there, we would have a better range of enforcement options for dealing with that. We think, I haven't touched on this before, but we think we can come up with a quicker and more proportionate appeals process, because uncertainty is not good for anyone, not the clinic and certainly not us either. We think the streamlined consent process, when I talk to staff in clinics, they often do tell me how complex it is. And we think this better medical information sharing would be of benefit to clinics too. If I look at donor-conceived individuals and donors, we think improved information at the outset about, people really need to know now that I think over the coming years, these DNA testing websites are real game changers in terms of ideas about confidentiality. We think these proposals would give more choice, so both parents and donors could opt for identifiable information much earlier in the child's life. And we think that the sort of compulsory information implications counselling would mean that people sort of consented to something much more, a much greater sense of what's actually, what they're getting into. And in terms of researchers, we think that this sort of flexibility really would, I think, put us in a regime that can better adapt to what is inevitably an inflexible law and a fast developing science. We think there would be improved supply of embryos for research purposes. So we're no longer dependent on those individual relationships. We think there would be a greater access to trials or innovations. And as I say, this point about making the Act more flexible means that one can see, in effect, it's a way of future-proofing. Just because, to be clear, just because those new treatment possibilities might be available doesn't mean we should, as a society, adopt them. but it would get us out of this problem whereby we have to go back to the primary law every time in order to consider these things. So I think it would make for a more responsive primary legislation. So what are the next steps? This gets me back to Sarah's point about optimism. This is clearly the start of something, not the finish of something. We've got a large number of responses so far, and frankly, the more the merrier. So please do participate. It's not a vote, though. What we're not going to do is then sort of total them up and say 51% of people thought this, therefore that's what the authority thinks. This is about getting a sense of where the consensus, if there is one, lies out there, and letting that inform the authority's deliberations. Our plan is to be in a position to put work through proposals to the government in the summer. Now, this is the realistic point that Sarah put. However much we've been talking to the department about this, they understand and support the idea of a consultation, they can see the case for change. That doesn't mean the law's going to change. That is a decision for government.
Our next speaker this evening is Venessa Smith. Venessa is Quality Manager for the Assisted Conception Unit at Guy's Hospital. Venessa has worked as an embryologist and as a coordinator of services for fertility patient and gamete donors. And I would say there's not much she doesn't know about the day-to-day workings of an IVF clinic.
So first of all, thanks, Pet, for asking me to talk about this consultation. When I've been considering the consultation, it's been quite a lot of reflection that's been required to answer these questions. And the section that I'm talking about is patient safety and promoting good practice. So as you're aware, the attitudes to clinical care, as Peter touched on, have changed enormously over time. The historical model is where the clinician has all of the control, makes all the decisions. And we've now moved to a setting where the rights of patients are a major part of the treatment pathway. This is obviously a very positive movement, but again, as Peter stated, the law hasn't moved with it. Now, the HFEA Act, as we all know, was introduced to provide a legal framework within which IVF could be performed, taking into account the needs of gametes and embryos. Since its introduction, there has been a number of amendments, useful amendments, for example, greater recognition for same-sex parenting. However, there's been limited amendments related to the subject of patient safety. And obviously the patient is a key element of every treatment cycle, whatever that may be. Now, the World Health Organization states that patient safety is a healthcare discipline that emerges with the evolving complexities in healthcare systems and the resulting rise of patient harm in healthcare facilities. The definition is apt for the fertility sector. Developments in IVF are often complex and controversial, and so the need for greater scrutiny of how these changes impact on the safety of our patients is clear. So with relation to this particular area of the consultation, the proposal is that the Act explicitly reference patient safety and that the HFEA have greater powers to take proportionate action. What I'm questioning is how this would change our current practice. Having just had an in-house unannounced interim inspection, it is clear that patient safety is increasingly an area of focus. We're expected to ask for patient feedback at every opportunity and act on the feedback to improve the overall patient experience. Rightly, we're required to offer counselling to all of our patients at multiple points within the patient pathway. Already, there are consequences following inspection or otherwise if the HFEA does not feel that the clinic are fulfilling their responsibilities. It would be difficult to identify clinics that do not act on HFEA recommendations. Peter may have some ideas regarding that. And how would including this in the Act improve the response? So there are a number of things we already do well, or I hope we already do well throughout the sector. As Sarah commented, I've worked in a number of settings, and so I've had the opportunity to work both in the NHS and the private sector. And the overarching observation is that the majority of people that care for these patients care very deeply about the subject and about the treatment. They want to provide a safe environment, they want to provide good results, and also they do follow their professional guidelines that all the nurses, doctors and embryologists all have. They also apply appropriate safeguarding measures, which have become increasingly important. Regardless of whether IVF is performed privately or through an NHS service, the inherent responsibility towards the safety of our patients, many of who feel very vulnerable, is obvious. The vast majority of staff in the sector work tirelessly to ensure that patients are protected, well informed and comfortable during their treatment and beyond, whether they are successful or not. The current code of practice provides multiple points of opportunity when the clinic can be assessed on its competency to practice, and much of this is related to our responsibilities to our patients. There are multiple audit requirements, instant reporting methods, inspections. We are supplied with updates and feedback and information regarding all manner of topics. However, we do need to remember that certain clinics will take note of these more than others and get involved more than others. There are clear definitions of what is not okay within a licensed setting, and staff are encouraged to speak up to the HFEA if they have concerns that they feel are not being addressed locally. The level of responsibility that the HFEA has over our patients already seems sufficient to encourage, ensure and protect when applied against our license to practice. How can this be improved for patients or clinics? So the question that I wanted to think about most deeply was question number 16. Now this, in the consultation, it says the Act should be revised to include an overarching focus on patient care. Patient care should be an explicitly stated principle of the Act, with a requirement that the HFEA decision-making and compliance should have reference to it. In the context of the consultation, question 16 specifically focuses on patient care and the level of responsibility that we feel the HFEA should have. Interestingly, in the patient care, in the question, patient care and protection is referenced as opposed to patient care and safety. If we consider areas of patient protection within general medical services, this is usually related to information sharing. However, in the context of this consultation, we may want to consider protections first do no harm, as so eloquently referenced in the Cumberledge report. One example I want to give of the success of the HFEA as a structure as it is now is the example of the impact of multiple births and the HFEA's work towards elective single embryo transfer. All of us will have seen this graph many times before. It's taken from the HFEA publication in 2019 of multiple births and fertility treatment. This shows very clearly the impact of the HFEA can have on outcomes in the UK and the way we treat our patients through collaboration and information sharing. It is safe to say that this project was a great success in a number of ways. Firstly, as shown on the graph, through the reduction of multiple pregnancy and consequently an increase in patient safety, more positive outcomes and a reduction in the pressure on our special care baby units. This is an example of a hugely successful collaborative project on the back of the One at a Time campaign in 2007. Perhaps we should be focusing on these kinds of projects as opposed to legislative changes that may take a long time to implement.
I'd like to now introduce our next speaker, Dr. Rachel Gregoire. And Rachel is the Scientific Director of the Hewitt Fertility Centre. She's an embryologist and she is Deputy Chair of the Association of Reproductive and Clinical Scientists. And I think she's going to focus on proposed changes to donor conception.
I think it's important, as Sarah says, that these views are my own. That I am the Deputy Chair of ARCS and I will be responding to the consultation as part of ARCS. With the ARCS Executive Committee, with their views, obviously, as well as my own, and also as part of the Hewitt Fertility Centre, we will also be submitting a response, but I will also do it as a fertility professional individually. So the views that I'm expressing here today, or opinions or thoughts, are my own. And with that fact, I think I've probably chosen the most, Sarah chose for me, so thanks for this, Sarah, the most divisive and complex and sensitive area of the potential changes, the proposed changes to the Act. And this area, within donor conception, the donor conceived, the patients and the donors will all have a mixed and equal range of views. And the impact of any changes that are or may be approved in the future will be felt differently by every family and every individual. And I think that's where the division will come in around this. So where are we now? Well, just to start with a little bit of data to sort of really push the importance of considering change within donor conception. Donor conception within fertility clinics is a significant part of the work that we do. We know now, as this was data published by the HFEA at the end of last year, that 1 in 6 of IVF births are involving donor conception. We know that the use of donor sperm in treatment has exponentially grown, it feels like, within the fertility sector. A graph I'm about to show from the HFEA data clearly shows that sperm donors that are now registered, over half of those are from outside of the UK, which is a really important fact that we need to consider as part of any proposed changes. And the big 2023, we all know that, with the law changes in 2005, towards the end of this year, the opening of the register for those people who were conceived by donor conception from 2005 will be able to access identifying information about their donors. So just to show some of the data here again, I just want to demonstrate, this clearly demonstrates the increase in sperm and egg donation in the fertility sector in the UK, and the use of donor sperm in fertility treatment really has grown since the changes within the Equality Act, the introduction of the Equality Act, and also obviously it's been driven by our same-sex couples using donor sperm to conceive. And happily for us, I can clearly see that, you can see just very gently the embryo donation is also growing slowly, which is really important to be able to use those embryos that are sat in storage and are no longer required by families. It's such an important thing to pick up on there as well. And again, as I just mentioned, we can now see that donors that are imported from outside of the UK has now taken over donors that are registered that have donated within the UK. And this is an important fact, because is this saying to us that there is a shortage already of donors, sperm donors in the UK? Or is this extending the choice of donors? Are our recipients actually actively looking elsewhere for a wider selection? Certainly within our racially minoritized groups, we know that access to donors that they want to use is difficult. So they are going further afield to look for the right donor. So where are the issues? Where do the issues lie? Well, we know obviously with the introduction of the Act, we all thought that anonymous was best. That's what was thought, and what we've learned from, and I should say that I work with our counselling team really closely, and our fertility counsellors they work and manage the donor conception register. So this is for the register for those those donor conceived individuals who were conceived when donation was anonymous before pre-Act, and in fact records of donation were actually potentially destroyed or removed, and we don't have records of those donors. So in those pre-Act days, it was anonymous, and I have got some insight. Again, I'm not an expert in this area, but some insight into the donor conception registrants and how they've coped with this anonymous donation in the past. Our views have changed, but the law doesn't reflect these changes, and we can all see that. As Peter mentioned earlier, we are all aware of the massive growth in direct-to-consumer DNA testing, the growth of social media, that really anonymity really no longer exists, and that information about donors is accessible. It may not be directly the donor conceived or the parents or the donor. It could be a third party within their family that then has genetic testing, and then the link is identified. And the response to the accessibility of donor information due to these commercial testing, the response from the parents and the donors and the donor conceived will vary depending on what information they want to find out and when. And I think I've just highlighted a couple of points in the bottom two statements on this slide. These were taken from part of the consultation, the wording around from the HFEA around this consultation, around donation really does raise questions about parental choice. And I think that's important here, that we're raising about where the parents should have choice to make informed and have informed decision making. And also that the recommendations that I'm about to go through seek to provide the patients and the donors with options. And again, I wanted to highlight that because the donor conceived not mentioned in that statement. So the first proposal for change, what I did is, and I thank Sarah for asking me to talk about this when it started, really has made me think about the consultation and the questions that have been asked. So the first proposal is that clinics should be required by law to inform donors and recipients of the potential of donor identity being discovered. I read that proposal and I thought, so what? Yeah, of course. But actually, when you start, and it's really important, I will say to anybody reading through the consultation, is read the supporting information clearly and read the specific question that is being asked with the multiple choices. I think that's really important because there is slight change and through the wording, and I wanted to highlight, and also when I'm going to answer those questions, I'm really going to think about the question that's being asked specifically before the multiple choice. So in my mind, as far as, I feel as a PR for a fertility clinic that we are a compliant, try to be as best of our ability, a compliant clinic. And when I read this, and the supporting information talks about how the guidance should now become a legal requirement, so that by law we should inform our donors and recipients. Well, by law we should be ensuring that our patients and our donors make an informed consent, and that they are told the risks and benefits of any treatment or options that have been provided to them. They have time and necessary information to consider the implications of that choice. So this, in my mind, putting it into law when it is already in the guidance wouldn't, I believe, in my perspective, wouldn't make any difference. So when I was thinking about, well, why does this matter and why would this matter to the HFEA? I am assuming, and I think that some clinics may be more compliant than others. Perhaps the fact that it isn't within the law means that some clinics don't ensure that informed consent is taken and that the donors and the recipients are given all of the implications. If that is the case, then yes, I agree. It should be put into law to ensure that informed consent is taken by all clinics. So it was taking some assumptions by what that is meant. When I respond to that question in the consultation, when I do respond, I'll have to put that into some of the free text to ensure that that point gets across. So the next proposal, and I want to spend a bit more time on this, and I'm probably going to ramble on and Sarah will stop me, was around the options that will be given, or the choice that will be given to parents and donors to opt in or opt out, as in opt in to the current, stay within the current framework in that they will remain anonymous until the age of 18, or the donor can opt to allow their identifiable information being provided to the parents at the birth of the child. And again, I want to sort of draw its focus onto the supporting information around this proposal, that under this scenario, donors must decide. So they get to choose whether they wish to remain within the existing legal framework or whether they choose to be identifiable before that time. And then if a decision is opt to stay anonymous, they know that obviously at the age of 18, the donor conceived will be able to access that information. And then the parent will get to decide at that point of treatment, do they want to use a donor who is open to having the information available, or do they choose a donor who wants to wait until the age of 18 of any child born? And again, in the actual question that is asked, to what extent do you agree or disagree that the act should be amended to provide parents and donors a choice? So I want to focus on that a little bit more. We all know that the current professional advice is that children should be learning from a young age their origins, their genetic origins and how they were conceived, and that clinics should continue to encourage patients to be open with their children about how they were conceived. So we have to enter it. We should be encouraging a culture of openness. So this proposal means that a donor conceived child who will hopefully have learned at a young age that they were donor conceived will have no right of choice if they're to be able to access information or be curious about their own identity or biological information until they turn 18. That choice has been made for them. And what we're doing is, again, removing choice from only a subset of our donor conceived and not others. Others will have that choice to access that information or not. Some will not. And is this potentially creating or putting the needs first of the donor and of the patient, the parent, and making those needs higher than the donor conceived, creating almost this two-tier system if this opt-in, opt-out option is considered? Or is it that we're thinking about selection of donors and number of donors and donor availability to allow, again, more choice to the parent? And the third proposal, I've not spent focus on my time, that the third proposal is the Act should require all donors and recipients to have access to information about the implications. I had a good heated debate with our lead counsellor on this one, and we often have good debates. And I thought what I knew her answer would be. And within the additional information, it's about counselling must be at the heart of a voluntary, counselling must at its heart be a voluntary decision. Our counsellors provide implications counselling to all our donor recipients and donors. We believe that's the right thing to do. But when I debated this, I said, is it counselling? Because you're providing information. And really, counselling should be voluntary. And her response was, therapeutic counselling should absolutely be voluntary, of course. But this is implications. This is considering the wider implications of their choice. And it could be just an information giving exercise given by anyone within the clinic, as long as the right information is given. But she said that by counsellors providing that implications information, they use their therapeutic skills. And they use their therapeutic skills to really explore openness, potential rejection, to sort of allow the recipient and the donor to self-explore and to confront their own fears. And they use the skills they have to do that. So again, within my response to this, should they have implications counselling? Yes, they should have provision of information for the implications of their choice. And I believe that should be delivered by counsellors.
It gives me great pleasure now to introduce Dr. Kay Elder. Kay is a senior research scientist at Bourn Hall and a contributor to the first UK research that involved editing the genomes of human embryos. Kay previously worked alongside IVF pioneers Patrick Steptoe, Bob Edwards and Jean Purdy, and she went on to publish studies of their notebooks. She's been involved in research for many, many years, and it gives me great pleasure now to hand over to Kay.
Bourn Hall obviously exists. In fact, the entire field of IVF only exists on the basis of many, many decades of very dedicated, serious research. And it has always been a priority. Obviously, both Patrick and Bob were very keen to improve the field and encourage research whenever possible. So, and although I'm going to speak about our experience from 2005 to the present, our patients were able to donate embryos for research before 2005. I'm just going to restrict the data that I show you to the last almost 20 years. I'm not going to read all this, but if we look at the HFEA website, there is a very, very strong and clear message that they support research. It's a bedrock for the development of new techniques, and the treatments we take for granted today wouldn't even exist So the HFEA has a very clear message that encourages embryo research, and there's a lot of information for patients on their website. This was again reinforced and confirmed with a survey of patients that the HFEA carried out in 2016. And these are some minutes that from an authority meeting that was held in 2017, where they confirmed that the majority of respondents said they prefer to donate their embryos to research rather than allow them to perish. And a lot of comments about the importance of research. But the reality is only 1 in 5 clinics recruit embryo donors for research. And around 25% of all embryos that are created are used in treatment. 50% are destroyed because they're unsuitable for treatment, and 25% are stored for future use. So the embryos that are donated for research tend to come from a very small number of clinics. At Bourn Hall, at least half of our fresh cycles have embryos cryopreserved. So last year, 600, 700 cycles, fresh cycles had frozen embryos in cryostorage. So at any time, our cryobank has approximately 4,000 embryos in storage. Our patients are invoiced annually for storage fee. It's almost £400. They're sent this form that you can see here on the left, and they're given options. Those who have not been successful in treatment obviously tend to continue storage and return for treatment. But those who do not want to continue treatment have the choice of donating the embryos to research, having them disposed of, or donated to another patient. But this is accompanied by a number of restrictions, obviously. When the patient returns the form to our patient services department, if they choose option B, I then send them a detailed patient information sheet plus consent form, and also information about counseling. They have the option of choosing to have free counseling if they want to discuss the embryo donating to research with a counselor. But in fact, I personally send out all of this information, and I always have done ever since we started doing this. So I started doing it in about 1989, I think, but more than 80% of the couples who receive the research information do agree to research. And when I look, I keep very close records of all the couples that receive the information, and I look at their IVF history. And when I looked at the details, more than 90% of them have delivered at least one healthy child. And when I looked at the data to the end of last year, that's the couples who had chosen to donate embryos to research had delivered 836 babies altogether, including 195 sets of twins, 29 families with 3 babies, and 1 family with actually 4 IVF babies, twins and 2 singletons. So this means that the embryos that are donated are actually from cycles of excellent prognosis with a very high viability potential. Obviously a very precious resource. And now that we are vitrifying blastocysts mainly, we expect to have more than 90% post-thaw viability. So this is data from 2005 until the end of last year. As a result of the embryos that were donated, having received signed consent forms and the detailed PIS, we have donated, Bourn Hall Clinic has donated about 5,500 embryos to 8 different academic research centers. So really a significant number. And these have led to some very, very significant publications in high impact journals, a lot of them in Nature and Science Development. And a list of publications can be found on our website. The use of donor gametes. Rachel has already mentioned a lot of this detail, so I'm not going to repeat it. 1 in 6 births using IVF are from egg, sperm, and embryo donation. So the number of children, as Rachel has already said, and Rachel has also mentioned that the use of sperm imported into the UK has increased. Furthermore, this is HFEA data. The IVF birth rates per embryo transfer were highest for patients in female same-sex relationships, who obviously have used donor sperm. And comparing patients using their own eggs, the highest birth rates were recorded for female same-sex relationships. So this higher birth rates using donor sperm should mean an increase in the number of surplus embryos from donor gametes, which we would like to think would be available for donation to research. However, license requirement R19, prior to giving consent, person providing gametes or human cells must be provided with necessary information, including both people who provided eggs and sperm to make the embryos need to give consent, and information about the nature of the research project. However, if your embryos were created using donor eggs or sperm, the consent of those donors would be needed. Currently, we have 85 sperm donors, and 30 patients have got assigned donor sperm that has been imported from abroad. The form was originally for 10-year storage, and I think, as Rachel's also mentioned, the 10-year storage was extended. So in 2017, we contacted our sperm donor bank, the men in the bank too, who were eligible to have extended storage. Only 23 out of 43 that we wrote to actually replied. And recently we've had, and again in contacting the sperm donors about extending storage, we had a couple of patients that were keen to use the donor sperm for sibling use, but the donor had only consented to 10-year storage. We asked the donors if they would consider extending storage, and they had mixed results. Some ignore the request, some are keen to help, but another couple are now considering counseling after we contact them. Another donor earlier this year told us he was in a relationship and his new partner didn't want him to be a sperm donor, so he's withdrawn consent. And patients who've had successful treatment using the samples can't use the samples for sibling use. So at the moment, we have about 60 donors that we need to contact and ask if they would like to complete the new MD form. But based on our experience, we will probably contact only about 25 of these 60. So the reality, when a couple want to donate embryos to research, remember, the majority of them have completed their family, they've got young children. If they were created with the use of donor gametes, I then write to the sperm donor, sending him the PIS and the consent form, hoping that he will return and give consent. But obtaining specific consent from gamete donors is really problematic. They frequently ignore or don't acknowledge the correspondence. And another interesting feature is that sperm will have been donated many years before the embryos were created. So at the moment, we have 40 embryos that were donated between 2016 and 18. Using donor sperm, but this sperm was stored between 2006 and 2009. So obviously not much hope of getting assigned consent from them. When we started our sperm sharing scheme, I asked the clinician in charge to give the sperm donors the research consent at the same time. And as a result of that, we got maybe 2. But as I'll show you in a moment, because the specific information has changed over the years, of the sperm donors who do return a signed consent form, they will have signed for an information sheet that we're no longer using. So over the past 8 years, we have only 11 signed consent forms from sperm donors. 9 of these, the consent form will no longer apply to embryos that are donated after 2018. 2 of them returned a form that we were using in 2021, but this is going to be replaced this year with a new version of the form. The other problem that I've experienced is that contacting sperm donors about consent to research has raised serious emotional and ethical issues with his current family. Because especially in the case of the sperm sharers or the egg sharers, if you ask them, another family, thanks to your very kind donation, wants to donate the embryos to research, and they have not been successful in treatment. This can be very distressing. And in fact, I had one gentleman phone me, and we had long discussions about this, saying, can't we use the embryos for ourselves instead? Can't these embryos be donated to us instead of to research? So at the moment, in our records at the moment, I'm preparing to send out another lot of embryos within the next month or 2. And out of the 153 embryos that are ready to be exported with signed research consent, 33 of them we won't be able to send because we don't have a consent from the sperm donor. And in our archive folder, we've got 110 embryos from 42 couples. And these 42 couples delivered 58 babies, including 10 twins, 3 twins plus 1. And 6 of them have imported sperm. So in our records at the moment, we've got 143 precious embryos. Currently, we will have to discard instead of being donated for research. And this is, it's ongoing because we keep the embryos until they reach their expiry date. So the second point that I'd like to address quickly is license requirement R19. They must be provided with necessary information, including the nature of the research project. Now, initially, we were using a fairly straightforward generic consent outlining important principles and details of the research, was basically understanding embryo development. And then it started to get complicated. In 2006, we had a new PIS because, well, we wanted to be able to share our embryo research bank with other academic centers who have all the facilities and resources. So in 2006, we were sending embryos to 4 different academic centers. But then after a round of research inspections, we were asked to change the PIS so that it was more specific, more project specific. And I protested. I said, this is not a good idea. It's not going to work. But in the end, we did do it. And we had a specific consent form that was related to 1 unit and 1 project. And then unfortunately, that project was discontinued. And we had 360 embryos allocated to that unit. We spent about 2 years discussing with the HFEA, saying, is there a way to get around this? But they wouldn't budge. We didn't find a solution, and we threw away 360 embryos. About 250 of those were pronucleate embryos, which are very, very precious and rare. So I'm not going to read through all this, but just to emphasize that every time we produce a new information sheet and consent form, it has to be reviewed by the local research ethics committees for each group that we are going to send the embryos to. So it's not done lightly, and it can take up to a year or more by the time it's been reviewed by all the different consent ethics committees. From about 2017 onwards, the HFE inspections of the research group seem to require increasing detail. And finally, in 2021, we were asked to produce a PIS that was specific to a specific project only. We just don't have the resources and the logistics to manage. You know, at that time, we were sending embryos to 5 different centers, and we just couldn't do that. So retrospectively, the embryos that had been donated using that particular PIS could be sent only to one project. And we're now preparing the next update. And again, because we've been asked by the HFEA to make sure that the information is project specific, we will only be sending embryos to one unit, which seems very unfair on all the others. But they were very much involved with our discussions, and they knew quite well that we did as much as we could to try to overcome this. As I've already said, the majority of the couples have got a young family. A complicated and cumbersome process is annoying and a major deterrent. And I have had patients say this to me: why are you sending me all this stuff? And if a project is abandoned or discontinued, the embryos can't be used. The consent is invalid, and that's a violation of the patient's wishes. So, in conclusion, the minute from the HFEA authority meeting says safe, ethical, and effective fertility treatment is a central ambition, and they want to encourage world-class research and clinical trials. So I suggest that the process of donating embryos to research needs to be simplified, streamlined, and perhaps centralized. From the patient's point of view, I think excessive specific information is unnecessary. And if it's too complicated and detailed, it actually puts them off. And for the clinic IVF lab, I can tell you that it is a huge administrative and practical burden. So it's discouraging for other groups that want to try it. I just want to finish by acknowledging our IVF lab have they've been very supportive in trying to fit all of this into the routine IVF work, because it's not easy. It does take several days. And I also want to thank Kathy Nayakan, who has been instrumental in guiding us with her infinite patience and tolerance, guiding us through all of the different patient information sheets and getting them through ethical committees and through the HFEA. And I think lesser mortals would have given up and gone back to animal research.
And we have the fertility clinic's favourite solicitor when it comes to regulatory matters in relation to the Human Fertilisation and Embryology Act, James Lawford Davies.
I'll try and keep it brief. It's a topic that I could certainly talk for hours about, but I've chosen 2 aspects of the consultation that I thought I'd focus on, and then another issue that I wanted to touch on briefly at the start. Before I do that, I wanted to mention the importance of thinking about the broader context of regulation in this area. There are very good reasons why we regulate IVF and embryo research in the way that we do, and I think it's important to realise and recognise that they date back to the 1980s. And as Peter mentioned right at the start, This is now quite ancient legislation from the Thatcher era, and she was very proud of laws that took us back to Victorian values, as she put it. But at the time when the Act was introduced and drafted, IVF was still a relatively new and some considered experimental treatment with a relatively small number of healthy children born, and a lot of social, ethical, and policy concerns around certain aspects of these new reproductive technologies and the opportunities that they gave rise to in relation to treatment. And there were lots of concerns about embryo research in particular being a slippery slope and leading to all sorts of ethical problems and dilemmas in the future. As a result of that, the legislation that was crafted and built around the field, both for research but also for IVF, was comparatively restrictive and conservative, and certainly precautionary. It is unusual to find a specific area of medicine that is so tightly regulated as a matter of law and subject to the sort of licensing regime that we have and that's implemented by the HFEA. And one of the things that I think is missing from the consultation, and I hope is something that will be revisited when the Act comes back to Parliament, is that sort of taking a step back and saying, well, why are we regulating IVF differently? Why do we have regulations specific to one treatment, which has now been provided to millions of people around the world and is no longer experimental? And certainly shouldn't be considered dangerous or justifying of different treatment in the way that we have in the shape of the Human Fertilisation and Embryology Act. And the first thing I wanted to mention that doesn't feature in the consultation, but I think really needs to be reconsidered, is the criminalisation of treatment and other aspects of the use and creation of embryos and gametes. And we just saw a lovely photograph of Bob Edwards there. He was very concerned about the idea of introducing criminal sanctions for the misuse of embryos or research techniques. But the government took the view in the white paper and maintained this throughout the debates on the Act, that a licensing system such as we see with the HFEA should be backed up by criminal sanctions. And I think this is one of the strongest indications of the concerns that arose in the 1980s about the risks associated with the creation and use of embryos, particularly in research. And there are lots of offences under the Human Fertilisation and Embryology Act. There are two main categories. There are the really dodgy offences, like the mixing of human and animal gametes, or the transfer of non-human embryos into a human. But then there's a second category of offences, which are still criminal offences, which criminalise licensable activity outside the scope or terms of a licence. And these are, I've described them on the slide as clinical and laboratory offences. These could still go to the Crown Court. They could still result under the Act in prison sentences or fines or both. And this came to be considered in the case of Diane Blood, who you may remember wanted to use the sperm of her late husband, either in the UK or to export it abroad. And I won't go into the details of that case now. Suffice to say that in that case, the court looked at the fact that there were no consent forms in place that had been completed by her husband. They weren't IVF patients. He was about to die and sperm was extracted from him. And the question arose, well, what could be done with it? And the Court of Appeal very carefully looked at everything and concluded that the processing and the storage of that sperm was a criminal offence in the absence of written consent. Now, there was no prospect or consideration given to prosecution in that case, but the case made it absolutely clear that storage without consent, storage beyond the statutory storage period, use, treatment, or breaches of confidentiality are criminal offences under the 1990 Act. And I don't think that this is the concept of a licensing system backed up by criminal sanctions that the government intended in the white paper. And it concerns me that we have the sort of almost routine practices, maybe sometimes in breach of guidance or in breach of regulations or material that's stored slightly longer than it should have been. It concerns me that that remains a matter of criminal law in addition to the licensing regime. Now, of course, there are circumstances where inappropriate conduct and criminal activity should be penalised appropriately. And the example that I've given here is the case of Paul Fielding, an embryologist who went to prison for cases of assault to patients because he was transferring water rather than their embryos, and also financial matters. But overall, my view is that the criminalization of day-to-day clinical and laboratory practice is extremely inappropriate in this day and age. The second thing I wanted to look at is one of the aspects that does feature in the HFEA's consultation, and that's this concept of better regulatory tools to tackle poor patient care. And the picture I put up here is probably familiar to at least some of you. It's a beautiful painting in the Tate called The Doctor by Salik Files. And you can take all sorts of things from this painting. You can focus on the poor sick child, the parents in the background, the distraught mother. You can see the dawn light coming through the window, and maybe that will give you hope. But most people focus, and the intention of the painting was to focus on the doctor, who has been sitting there all night and is deeply concerned but calm and authoritative in the way that he's regarding this poor, very, very sick child. But if you pause for a minute and imagine an HFEA inspection report of this, it would focus on the fact that this is a poorly lit room. It doesn't appear to be very well ventilated. The doctor is not wearing appropriate clothing. The parents probably shouldn't be in the room at all, and they've left clothes lying around. There's rubbish on the floor. The child isn't in a proper bed and isn't supported properly. There's medicine on the table which doesn't have a label on it, and it's not CE marked, and so on and so forth. Now, I'm making a slightly flippant point, but the more serious point that I do want to make is that, like that doctor, who's perhaps romanticized in the painting, the vast majority of people that I encounter and have encountered in 24 years of working in this field, be they doctors, embryologists, nurses, counsellors, or administrative staff in clinics, do their jobs because they really want to help people have children, and often against all odds. And they are regularly perplexed by the overtly negative and critical reports that they receive as a result of HFEA inspections, which I understand have to focus on non-compliances, and it's quite right that serious non-compliances are identified. But there is a tendency for them to focus on administrative and often, I would say, quite petty oversights and problems. And this concerns me for two key reasons. The first is because patients read it, and would-be patients read those reports. And anyone would be forgiven for thinking that the sector is in a bit of a state, given the number of critical and major non-compliances that you find for not an insignificant number of clinics, if you, like me, take time to actually read the minutiae of these reports. The second thing that concerns me about it is these reports go to HFEA license committees. And this is the nub of the point that I want to make, really. The HFEA, and this isn't a criticism, the HFEA is not an expert body. It has a lot of expert advisors and very, very clever people that give it advice. And some of the members of the authority do have experience of working in IVF clinics. But it was the intention of the Warnock report, and it's built into the 1990 Act, that it has to be a lay majority. The chair in particular and the deputy chair have to be lay, and there has to be a lay majority in terms of the members of the authority. Now, although the Act refers to medical practitioners, there's no requirement that HFEA license committees have expertise in genetics, research, counselling, nursing, etc. as a matter of law. There's similarly no requirement for there to be any practical experience of IVF clinic work and operation in the constitution of a license committee. So you do find that decisions are made by committees made up of people who have never set foot in an IVF clinic and have no practical or professional experience of how they work. Now, I am concerned about how they would interpret a report that highlights critical and major non-compliances. And I'm also concerned about how they would manage the new powers that are proposed and suggested for imposing financial penalties on clinics. And likewise, I have concerns about the proposal to expand the remit of the HFEA. As I've said at the start, IVF is now routine. and safe for in the vast majority of cases. And I think overall we should be looking at the relaxation of regulation, not expanding the remit of the regulator and reinforcing their powers. What's also suggested overlaps with a number of other existing regulatory frameworks, and I think risks increasing the burden of regulation for clinics unnecessarily, where there are other regulators that already take responsibility for both professional practice and other aspects of the operation of clinics, such as advertising and promotion. So in terms of the constitution of the HFEA and the membership, I think either it should focus on being a lay panel that expresses its ideas and opinions about ethics and policy and guidance documents, or it becomes an expert body like the MHRA or the FDA, where when you engage with a regulator in those circumstances, you're speaking to somebody who knows as much, if not more, about what you're talking about than you do. The third point I wanted to make relates to the issue that's raised in the consultation about making licensing decisions more efficient. And I completely agree with what the consultation document says about the need to revisit the licensing and appeals process. Now, many of you won't ever have had to deal with this, but for clinics that get into difficulties with the HFEA, it is a nightmare dealing with these procedures. They're incredibly complex. They are, as the consultation document says, they become quasi-litigious. So the hearings take place just like in a court, with armies of lawyers at great expense and take an enormous amount of time. The last licensing process that I went through, I think, took nearly 9 months from start to finish, during which time there is great uncertainty about the status of the license for a clinic in those circumstances. And they are, of course, enormously expensive. And I do wonder whether some other clinics may have pursued the process had they not realised how much it was going to cost to do so. So I certainly do agree that it's something that should be revisited and revised, but that needs to be done very carefully. And it needs to be fair and transparent in the way that it happens. It needs to be proportionate, and it needs to be efficient, which requires a degree of expertise. Now, the proposals that are set out in the consultation document seem to be quite innocuous, but I wanted to finish by just mentioning a case that I was involved with a number of years ago, where things didn't really go very well. The photograph there is a bit pixelated because it's a still from a BBC Panorama programme, which was about 2 clinics in London run by a doctor called Mohammed Taranisi. And the HFEA chief executive obtained a warrant to raid Mr. Taranisi's clinics with the police and HFEA inspectors, and also the Healthcare Commission, which was the predecessor to the CQC. The boxes that are pictured are actually largely empty, but it was a good photograph. And that warrant to raid the clinics was ultimately quashed. There were libel proceedings against the HFEA and the BBC, which were settled. Cases referred to the police were never pursued. GMC cases were thrown out halfway through. And then there was a prolonged licensing dispute. And ultimately, none of it went anywhere. And this was of concern to the next chief executive of the HFEA, Alan Doran, who wrote a report on what had happened. And this quotes him because he identified that something had gone badly wrong over a sustained length of time. And the HFEA had been focused on one person responsible who ran 2 clinics. Now, the staff involved have all moved on. It's a different organisation now with different policies which are meant to protect against this sort of misbehaviour. And I'm sure Peter will reiterate that. But things do go wrong. And as I say, the recommendations and the proposals to expand and reinforce and change the powers of the authority to allow them to be more flexible in the way that they impose licensing decisions need to be very carefully reviewed and considered. And I would hesitate before expanding the powers of the authority because, as I say, we are a long way away from where we were in the mid-80s in terms of the safety and the reliability of clinics and treatment.
This first one is from Tracy Sainsbury. Tracy says, and I think this is perhaps for Peter in the first instance. Could you confirm if you're anticipating implications counselling being carried out by appropriately qualified counsellors, or if other staff would be appropriate in counselling patients ahead of donor conception or donating?
To be completely frank, Sarah, that's not at this stage a kind of level of detail that we've worked up. So, I mean, I think it's important to sort of understand where we're at here. At the moment, we're trying to identify, some broad proposals for change and putting them out to consultation. And that's precisely the kind of added detail that might come back on the consultation. I mean, our general approach on the counselling is, clearly we want it to take place by appropriately qualified individuals and the like. But as I say, I think that's the point of a consultation, is exactly let's see what people have got to say, and we'll consider these issues over time. What these are, as I say, these are proposals for possible change, not fully worked out detail.
Can I jump in there? Sorry,
certainly,
Sarah.
Rachel.
I'd seen that question. It isn't necessarily counselling if not performed by a qualified counsellor. I think it's difficult, isn't it? Because often I have spoken with our medical team, for example, who have said it's okay, they don't need to see a counsellor. I have counselled them. Have you? Have you really explored? Have you helped them explore the implications of what is going on, of what they need to, their choices? And the answer is no, we don't have the same skill set. We don't have the same skills. I certainly haven't got counselling skills as our very well experienced and skilled fertility counsellors have. So I think if it's counselling, it should be delivered by a qualified counsellor.
Anybody else want to come in on that? Nope. Okay, I'm going to move in the interest of time to the next question, which is from Hayley King, who wants to know, will the HFEA be looking to restrict worldwide family limits, not just UK family limits? As you have presented this evening, the majority of sperm donors are from imports from countries and banks that do not have a max worldwide limit. And as such, UK donor-conceived people are being born into sibling groups of hundreds. This is unacceptable and makes a mockery of our current laws. And Hayley's, I think, a donor-conceived person and parent. So, Peter, do you want to come in on that first?
Okay. So crucially, right, fundamentally, our regulatory regime extends to the territory of the UK only. What we do in respect for imports is that we require importing clinics to ensure that the gametes that they're importing meet the varying laws and policy requirements that we apply in the UK. But, to be clear, we have no jurisdiction over what goes on in Denmark or anywhere else. So, if they're importing, a UK clinic is importing gametes from somewhere else, they need to check, for example, that appropriate screening's being done, that they need to ask some fairly searching questions about things like the numbers of families that have been created with the gametes and so on. But clearly, as well, in other countries which don't, for example, have either controls about family sizes or registries or something, in many cases that information is not available. So, I understand entirely where the question's coming from, but as a sort of practical matter of what's possible, for a UK-based regulator with UK regulations, there are clearly limits.
Ursula wants to know, will Section 2 of the consultation on access to donor information apply to those alive now or born before any act was passed? So I suppose, will it be retrospective? Generally,
laws rarely in this country apply retrospectively anyway. And crucially, I mean, in the case of donated gametes, the donor will have given consent at a point in time. Consent is a pretty important principle within the law. And the problem with retrospective application is it effectively overrides that original consent. Now, clearly, I understand how, because there's not just, there's a donor and there's a donor-conceived individual, but actually our thinking at this stage is that any changes are prospective rather than retrospective.
I think also in supporting what you're saying, Peter, is that I know the numbers are low, but there has been opportunities for people who have donated during the anonymous period, have been given the opportunity to actually change their consent. And I know the numbers have been fairly low, but maybe that's just because there's not been an awareness of that system. But I think you're quite right. If someone said they want to be anonymous, it's really difficult to then say, well, thanks very much for your donation. We're really pleased it was successful, but now the rules have changed. But I know that's a complicated concept for donor conceived people to take.
And I agree, Venessa, because I think we use a local ethics committee to go to consider even if we should approach the donor, because they've made their choice, they've made their decision, and to go back and almost feel that we're putting pressure on them to consider changing their previous consent. It's very difficult.
It's funny because when you mentioned the changes in the law, because I was working in a sperm bank at the time, and I remember really clearly the whole conversation around anonymity, and it was a frightening time, wasn't it, of knowing whether we were going to have donors or we weren't going to have donors. But I do remember at the time there was a lot of discussion about the donors that had already passed through the system and how we've got to look after them too.
Another one about donor conception from Leah Gilman, and she says she's thanking everyone for their presentations, but in relation to donor information, she's wondering why within the dual track proposal there's an attachment to 18 specifically as an appropriate age restriction, if there is one at all. Why 18 and not younger, e.g. 16 or 14, or just something like when sufficiently mature, as is done apparently in other jurisdictions? So was there any rationale behind that, Peter?
I mean, at this stage, it was about a continuity, if you like, with the existing regime. So what we were trying to open up was the idea about whether or not we ought to be providing parents and donors with choice for much more earlier information. So you're right. I mean, 18, I suppose, in the existing law just follows the age of sort of legal majority sort of thing. One could revisit that. And similarly, what we've not done in the consultation is specified when we talk about early access to information, we haven't sort of said that should be 1 month after birth or 1 year or something. That seems to us to be a detail. I think at this stage, it was just about trying to establish whether people had views about the principle of giving people choice, if you like. They could opt for one system or the other, rather than getting too hung up about whether or not 18 is precisely the right age.
Anybody else want to come in on that one? If not, I'm going to go to a question from James Duffy, who says the CQC has just published their annual review regarding the quality of maternal status. Do you think the proposed changes will result in a similar review regarding fertility services within a national context, addressing quality, i.e. safety and experience?
I'm not sure to what extent that actually law reform is required to do that anyway, sort of thing, in a sense to me. It seems to me we've already started to produce reports, based on sort of not just trend data, but like the report recently on ethnic sort of donation and ethnic minorities and so on. So I think it becomes much more of a kind of policy question for us about devoting scarce analytical resource. So it's certainly something I could see in the future us wanting to think about.
The way we're inspected now, and Peter, you can correct me if I'm wrong, is that we have a kind of like CQC element anyway. So it kind of stands to reason that changes made to the CQC may have a kind of shadow over what's inspected when we do. I don't mean shadow in a negative way, but an impact, I suppose. And I thought one of the issues that we had, and one of the reasons the HFEA kind of combined that CQC role, was to prevent us having multiple inspections,
Indeed.
So inspections by the CQC and by the HFEA.
Indeed.
And I think that was a really good plan.
And for the vast majority, there are now only very, very minor exceptions whereby a fertility clinic should have any involvement with the CQC at all in England, or its equivalent bodies in Scotland, Wales, and Northern Ireland.
Okay, so one from Laura Brigden's for you, James, because you talked about the constitution of the authority members. Do you think the constitution of a licensed committee such as the HFEA should include those humans created by the industry it regulates? I think Laura is chair of the donor conception registry, so I think that's the sort of angle that she's coming from on this.
Well, I think everyone has to be human to apply to be on the authority. But as for the humans created by treatment, I know that there have been many members who have been involved with donor conception or other patient representative groups. And I don't, Peter would know better than me, I don't know if there's been a donor conceived member. I suspect not.
I don't think so, but your broad point is right, James. Yeah. I mean, I don't think so. So
it's open to anyone to apply when the vacancies come up, and then there's a formal process for appointment and selection. Nothing at all to stop somebody applying.
So there you are, Laura. Next time there's a vacancy that's appropriate, consider applying. So then a question from Heidi Brandon. Could legislation be considered around requiring DNA donors to have to disclose any future diagnosis and make reports available to clinical genetics? Carrier preconception testing doesn't test for everything, even if it's undertaken. I don't know who wants to go with this one first. I suppose it would involve donors having to recontact clinics if they find a problem. Rachel.
I can try and answer some of it in that, yes, all donors are informed that it is their responsibility to report back to the clinic they donated to if a genetic condition arises in the future. They are all given that information as part of their provision of information, I suppose, before they treat, and as they leave almost discharge from the service. We encourage them to keep in touch anyway, to keep in touch with their updated addresses and so on. And carrier screening and extended carrier screening is difficult in that we import, obviously, a lot of donors that have extended carrier screening, and clinics need the relevant genetic support to review any carrier screening to consider what the relative risk is in the UK within certain populations. And that is complex, and we need clear guidance from our professional bodies on extended screening, which will hopefully be coming soon.
Anybody else want to come in on that one? If not, I will move on to a quick question from Amapreet Kaur, who asks, will responses to the consultation eventually be made publicly available, Peter?
Yes, is the short answer. I mean, clearly we will not do it in such a way that people are identified or something or other, but we will be publishing some form of, whether as an annex to a report or a separate thing, we will be publishing some kind of document that gives people a sense of the responses to the consultation.
Jenny Wordsworth asks, I think this is to you, Peter. You mentioned wellness and well-being treatments taking place online in unsatellite clinics that are not HFEA regulated. What kind of treatments are you referring to? I have to say, I did write a note there down, because I've seen a proliferation of fertility coaches and all sorts of different things, and I was wondering if that was what you were thinking.
For example.
Okay.
There's a whole range of these kind of things which flare up every now and again, where you could take vitamin supplements, sort of a drip for all sorts of things and so on. So there is part of this comes from us talking to patients who say they feel pretty confused and bombarded by a set of ancillary things to their treatment, sometimes encouraged directly by the clinic, sometimes through online and so on, what used to be just a fairly confined medical treatment is now a kind of set of things, and I suppose when I talk to patients, the sense I get from them is they sort of struggle to see why one defined element of what they're going through has sort of general regulatory oversight, and a lot of this other stuff, which they find equally confusing, doesn't.
So the next question I'm going to go to is another genetics related one, actually, and this is from Sophie Pete, who says, in the context of licensing and assessing clinics, is the quality of the genetic test used by the clinic considered? E.g., genetic tests are needed to screen embryos for PGTM, but some centres may be using genetic tests that are less accurate than other centres, creating an inequality in access and I suppose potentially a poorer service for patients.
The genetic testing service needs to be UCAS accredited. And they will have their own EQA and IQC schemes, to ensure quality assurance of the tests that they're performing. They will need to be assessed on that every year to get their UCAS accreditation, and we can't use a genetic testing provider unless they have UCAS accreditation.
I'm going to break my rule and ask someone who's already asked one before. Laura Briggins, she wants to know whether the non-response from past donors about consent to research reflects in the numbers of non-responses that donor-conceived people are likely to receive if they make contact. Is it just, donors have done their thing and then they don't want anything, whether it's to do with research, whether it's to do with the children?
Oh, absolutely. And that is definitely my impression. And especially, I've written to hundreds of donors and they just don't acknowledge or reply. They just, and it's sort of the same when patients who've completed their family and they want to donate embryos to research. They don't want to deliberately destroy them. They think that's, a terrible waste. They know their children are very precious, but they really, having made the decision to donate to research, they don't want further contact. And I discovered this way back in 2010, 2011, when all of the 350 embryos were destined to be destroyed rather than donated to research, which was a complete violation of what the patients wanted. And because so many of them were pronucleates, which they're, pronucleates for research barely exist anymore, because everything goes to blastocyst stage. I wrote to a number, well, I didn't write to all of them. I wrote to the ones who had large cohorts of pronucleate embryos saying, would you be willing to sign another consent form? And the majority just didn't reply. They don't want to, having reached that point and they're happy with their families, they don't want to be reminded of all the stress and trauma of going through IVF, because, it hasn't got any easier for patients. It seems to be, it's promoted as being much more streamlined, efficient, etc. But emotionally, it's still an awful roller coaster for every patient that has to go through IVF treatment.
No one would dispute that IVF, 30 years on, isn't a much more routine treatment from a medical perspective than it was all those years ago. I was talking to a group of patients on Monday night, and what struck me about it was, from their perspective, it all felt very new and very fraught and very charged and very difficult. And clearly, if you work in a clinic and you do this all the time, it may seem very routine. But from the perspective of patients, the idea that it was just like any other treatment would have got, a very, very strong response, was my sense. So, yes, I think we need to acknowledge that it's not as it was all those years ago, but we mustn't lose sight of the fact that from the perspective of the patients, this is, an extraordinary, significant moment in their lives. And the ones I talk to are looking for, they recognize, not in the fine print, that it requires some kind of specialist oversight.